In 2023, India passed the Digital Personal Data Protection Act, or the DPDPA, to protect your personal data. Unlike previous drafts of India's data protection law, the DPDPA did not mandate data localization, which is the idea that data about a country's citizens should be stored inside its borders. But fast forward to the issuance of the Draft Digital Personal Data Protection Rules 2025, or the DPDP rules, and suddenly data localization is back, without warning and without explanation. So what's going on? And more importantly, why is data localization a problem? Data localization is a policy approach that requires personal data generated in a country to be stored and processed within that country. There are two main models: full localization, where data never leaves the country, and mirroring, where a copy of the data stays in the country, even if the original is transferred and processed abroad. Data localization provisions may also embody one of two approaches: a whitelist approach or a blacklist approach. In a whitelist approach, data transfers are allowed only to countries that a government considers trusted or safe. For example, Article 45 of the EU's GDPR permits data transfers to countries that provide adequate protection to personal data. In contrast, India's DPDPA uses a blacklist approach. This means that the government can ban data transfers to specific countries. For example, Section 16, Clause 1 of the DPDPA lets the central government restrict personal data transfers to any country it notifies. While it's argued that data localization will boost economic growth, ensure data security, and grant law enforcement agencies easier access to data stored outside India, in reality, data localization may solve none of these problems and instead create a whole lot more. One case for data localization is that it will boost the economy by creating jobs and fostering a vibrant domestic data center industry. But there are serious concerns with this claim. A 2014 study by researchers from the European Centre for International Political Economy indicated that economy-wide data localization measures would lead to a 1.4% drop in India's GDP. Data localization can also significantly increase costs for businesses, especially startups and MSMEs. Because businesses don't store data by geography, they need to incur additional costs to segregate Indian users' data from that of others and invest in new storage systems. In fact, a 2015 study by the Leviathan Security Group estimated that data localization measures increase the cost of hosting data by 30 to 60%. Now, while larger companies can absorb these costs, it could end up hurting smaller businesses. Data localization could also affect such businesses' ability to scale and compete globally. Currently, India holds only 3% of global data center capacity. It could take several years for domestic data centers to offer services with features that are globally competitive. But in the meantime, businesses may face hurdles in accessing technologies and services that are key to their growth. And due to these higher costs, even new businesses may think twice about investing in India. Existing ones may choose to reconsider their future here. One study even pegs the potential investment loss at $18.4 billion. In short, data localization could slow down the growth of startups and MSMEs by increasing storage and hosting costs and reducing investment in India's tech ecosystem. One reason the DPDP rules bring back data localization is ensuring data security. But again, evidence casts doubt on this claim. For starters, forcing local storage actually expands the attack surface by increasing the number of physical servers that businesses must maintain. Local data storage providers also tend to have a lower budget and fewer resources than global ones, making personal data on their servers particularly vulnerable. Such weaker protections could incentivize bad faith actors to target organizations in countries with data localization mandates. In fact, research by scholars like Swire and Kennedy Mayo finds that data localization hurts companies' abilities to meet 13 out of 14 controls under the ISO 27002, a widely used cybersecurity standard. They caution that due to these difficulties, data localization may cut a country off from state-of-the-art cybersecurity protection. And then there's encryption. Many global firms use end-to-end encryption, and localization does not force them to decrypt any information. This instead requires a legal mandate, one that could weaken cybersecurity. Companies could respond by withdrawing such privacy-enhancing features. Or worse, they might become targets for cyber attacks because centralized data tends to be a jackpot for hackers. The takeaway is that data localization could weaken data security, not strengthen it. Another reason behind the push for data localization is to help Indian law enforcement agencies access personal data stored in other countries for criminal investigations. But even businesses that store personal data within India are subject to other countries' laws that prohibit the disclosure of such information, potentially creating a conflict of laws. For example, the US's Reforming Intelligence and Securing America Act, RISA, and the Foreign Intelligence Surveillance Act, FISA, empower the US government to access communications data outside its borders. But at the same time, the DPDP rules prevent companies from sending that same data to other countries unless the central government permits them to, possibly with certain conditions. This may create a compliance trap for global companies and possibly push them to exit the Indian market to avoid legal conflict. India could technically pursue executive agreements under the Flawed Act, the Clarifying Lawful Overseas Use of Data Act, like the UK and Canada have done. These executive agreements allow foreign law enforcement agencies to obtain streamlined access to communications data directly from US service providers. But to do that, India's data protection law must meet certain requirements, like a commitment to the global free flow of information. And data localization is inconsistent with this requirement. Some of the data localization provisions under the DPDP rules also apply unevenly to different businesses. For example, Rule 12, Clause 4 of the DPDP rules prevents significant data fiduciaries from transferring certain kinds of data specified by the central government outside India. A business can be labeled a significant data fiduciary based on the volume of personal data it handles. But using data volume to decide cross-border transfer rules is not ideal because privacy risks also depend on the type of data and how it's used. Despite this, the DPDP rules still place stricter limits on significant data fiduciaries, even when other businesses that are not designated as significant data fiduciaries handle the same kind of personal data. Most businesses also don't end up storing different types of data in neat little silos. So when a provision like Rule 12 Clause 4 kicks in, they need to restructure their entire storage setup just to stay compliant. And that can again entail extra costs and a lot of operational hassle. So what's the alternative? To enable cross-border data flows without compromising privacy and security, India could consider allowing data flows where businesses provide adequate safeguards through contractual clauses. This broadly mirrors global approaches followed under frameworks like the EU GDPR and the APEC privacy framework, which allow transfers if appropriate safeguards ensure continued data protection. Bottom line, localization is bad for India's digital future when more proportionate solutions exist.
This is the SCR Center. If you found this video useful, please like it and share it. You can also follow our LinkedIn page for more explainers and other updates.